Hi, and welcome everyone to this special Pepper podcast. I'm Brian Dolan from the law firm Pepper Hamilton. We are joined today by Pepper partner Matt Adler and associates Kate Puccio and Ryan Peters. Matt recently authored a new textbook on arbitration with the help of some Pepper associates, including Kate and Ryan. Now, the book is entitled Arbitration, Cases, Problems, and Materials, and is designed for law schools. Matt, let me start with you. Can you give our listeners a little of your background and why you thought this project was worth your time?
Sure. I think that the dual approach in the book reflects my dual background. I have been fortunate enough to be doing arbitration since I was a second-year associate at Steptoe & Johnson in Washington. I was on an early Iran U.S. Claims Tribunal case, and so got my feet wet very early in my career just with arbitration and with that practice. And I continued to do that when I left Steptoe and went to the State Department, where I did almost exclusively arbitration, usually against Iran, sometimes against other countries, including a major arbitration we had against the government of Chile, again, as a young lawyer for the State Department. And I continued to do that as a practicing arbitrator once I joined Pepper, and I've been lucky enough to be at Pepper since 1989, and I now chair our arbitration group. So that's the practice side. But I come from a family of educators. My sister was a 30-year high school English teacher, and I've been lucky enough to be a law school professor since 2005, first at Rutgers Camden Law School, and for the last 3 years at the University of Virginia School of Law. And I started teaching international law, moved into international arbitration, and realized quite simply that more of my students were going to have potential careers in domestic than in international arbitration, and that there really weren't any great books out there, with apologies to my very skilled colleagues who may have books out there. None of them appealed to me, and so I put together my own set of readings. Ryan Peters, in particular, was instrumental in that many years ago, and began to teach from that. And I wanted to focus in the book what I focused my career on, which is, again, a mixture of the practical and the pedagogical. And so we really were aiming for a mix of cases that taught the law of arbitration, but also practice pointers that concentrate on the practice of arbitration. So the book is a combination of my career so far.
So the book follows the same three-part chronology that arbitration lawyers must follow: organize the arbitration, conduct the arbitration, and finally enforce the arbitration. Can you give our listeners a little bit more about what each unit entails?
Sure, and I would stress that you've stated it exactly correctly, and that's a chronological approach. So the best way that I explain this to my students, and that I would ask listeners to think about it, is the attract-repel relationship between arbitration and the courts. And I promise I'll take that back to the three stages. Arbitration, if you really think about it, the plain and simple definition of it is the privatization, the outsourcing of a dispute. It's like going to Federal Express instead of the U.S. Postal Service to send a letter. And so when we outsource the dispute, we say, no, we don't need courts to do this. We'll pick an arbitrator and we will resolve this privately. Where courts come in is at two of the three phases that you just talked about. Because part one is organizing the arbitration. Well, how do we organize an arbitration? Quite simply, the parties agree to privatize it. They have an agreement, either in their contract about the sale of a business or a sale of goods, or later on in the commercial relationship if a dispute just happens to originate. The Congress in the 1920s passed something called the Federal Arbitration Act, which says we like arbitration. It's a terrific release valve for the courts. As a consequence of that, the early sections of the Federal Arbitration Act, sections 2, 3, 4, and 5, instruct courts to enforce arbitration agreements. So stage one of arbitration, part one of the book, is all about how we get to arbitration, when courts enforce it, when they don't, when they say an arbitration agreement covers a dispute, when they say it doesn't, and who, this is really interesting, who decides, the court or the arbitrator, about those disputes. That's part one. In part two, we get to how do we actually do the arbitration. Those are the mechanics. And some but not all of that is like any other court dispute, but not all of it. And one of the things we really pride ourselves at in Pepper Hamilton is that we don't treat arbitrations like court cases. We treat arbitrations like arbitrations. And we can always tell when we're going to an organizational conference or when we're in the middle of a case, when we're up against a very skilled litigator who has no bloody idea about the distinct parts of arbitration. So we cover such things in part two of the book as how to pick an arbitrator, when an arbitrator might have conflicts, how to get discovery from parties in arbitration, how to get discovery from non-parties in arbitration, when you can get an injunction in court even though you might have an arbitration clause, when you can bring third parties into arbitrations, and the notion and the limits of confidentiality in arbitration. And all of these, Brian, are extremely unique features to arbitration that go above and beyond the very, very difficult skills that all of us as litigators have, which is how to win the case. With arbitration, just as with court cases, there is a veneer, a layer of procedure that you have to know in order to get the job done. And so part 2 of the book tries to convey to anybody reading it, be it law student or practitioner, those unique features of how to actually win the case. That takes me to part 3, and you'll recall that I talked earlier about the unique attract-repel between courts and arbitration. Again, courts try to stay out of arbitration, but the Federal Arbitration Act also says not only that we should enforce arbitration agreements, but that we should enforce arbitration awards. Awards, by the way, is arbitration vocabulary for judgments. And so the Federal Arbitration Act says that once an arbitration award is rendered by the arbitrators, it's enforced. It should have the same power as a judgment. And think about that. That's a very odd thing as a matter of social policy. You're saying that an outsourced private dispute should have the same force of law as a court judgment. And Congress says, yes, it should. Those are the later sections 9, 10, and 11 sections of the Federal Arbitration Act. And in part 3, we talk about the widespread nature of that and then the very, very limited exceptions. And let me just say this without getting overly academic. Anybody who goes to law school remembers from law school that we study appellate cases, and appellate courts are there and always have been in Anglo-American jurisprudence because there's a notion that the law is pretty hard and courts get it wrong. There is no ground at all in the Federal Arbitration Act for not upholding an arbitration award just because the arbitrator got it wrong. Legally wrong arbitration awards can and are be enforced. What happens instead is if there is improper procedure, they won't get enforced. And that, again, is a startling difference between court and arbitration.
Now, after reviewing the book, there is a special chapter in Unit 3 on international arbitration. Why is this so important right now?
Your question is very well timed in this podcast because it springs right from my just talking about part 3 of the book, which is enforcement. And that's the springboard for why international arbitration is not merely so important and such a unique feature of the book. We devoted a particular chapter to it, as you've just noted, but such a large part of commercial relations. And it really is this simple. International arbitration awards get enforced more than do domestic court judgments. The United States is party to a treaty called the New York Convention. Over 150 countries are party to that treaty. It works because it's popular, and it's popular because it works. And by that I mean that if you win an award in the United States against a company whose assets are in France, you can go right into French court, because France is also party to the New York Convention, and say, hey, I have this arbitration award that I just won. Please enforce it against this Paris bank account of the French company that I just beat in America. We call that enforcement. And the clients listening to this will be particularly interested because nobody wants to pay twice to win a case. You don't want to have to, at the second stage of a case, when you're just chasing the assets after you've already won the case, have to relitigate the merits all over again. You don't want to have to go into French court and say to the French judge, hey, here's why I should get these assets. And so enforcement means only having to win on the merits once and then being able to actually collect the assets. International arbitration, to answer your question directly, works because the New York Convention says you only have to win once, and then international arbitration awards can be enforced anywhere. And that's extremely important, and that's a bedrock to international commerce. By sharp contrast, and some might say unfortunate contrast, the United States is not party to a judgment enforcement treaty, even bilaterally, one-on-one, with any other country in the world. We couldn't even conclude a bilateral judgment enforcement treaty with England, and they are a common law country that shares a lot of our system. And that's because no country wants to make their citizens what they would call hostage to high U.S. jury awards, to treble damages, to some of the things that make our system unique. I'm not commenting as a policy matter on whether those things are good or not, but as a matter of real world, what people want to partner with us on. They will partner with us on international arbitration, and they won't on court judgments. And so that's what makes international arbitration so very important. I don't think that we would have a fraction of the international commerce that we have without the New York Convention and international arbitration.
Kate and Ryan, let's turn to you and discuss your role with this book. We'll start with Kate and then go with Ryan.
So my role and the role of the other associates that have participated in this was really to help Matt make sure that everything about this book was absolutely up to date, up to the minute. We were making changes to things literally up to several weeks before the book was printed because of the current political climate and certain things that Congress and the executive branch have done that have affected or will affect arbitration. Similarly, as Matt has described, there has been an explosion of arbitrations over the past, I think there's a chart in the book, 10, 15 years. And so because of that, arbitration has received increased scrutiny. There has been an explosion of case law dealing with arbitrations, and we really wanted to make sure that the book reflected all of this. So myself and the other associates who worked on this, really, we did a lot of the research to make sure that every concept, every idea that we were putting forth, that we looked at it from every angle, from every court decision that has been written on it, and also from everything that is pending in Congress, especially dealing with the CFPB and potential changes that we could see there.
Well, I think to properly appreciate our role, you sort of have to dial back and think about the impetus of the book. And that was, Matt was my law professor in Rutgers, and he was teaching me arbitration. And there was a lot of printouts of the cases, mostly because arbitration has been and still is a developing area of the law. There was constantly new Supreme Court cases and other controlling cases that changed the law that we would then print out on LexisNexis or some other medium in order to hold a proper class. So Matt and I sat down and said, there needs to be a book about this developing area, lots of common law being done, and so we started. So our role was to research and compile the original basis of cases that sort of started arbitration case law along, and then sort of develop the changing laws that went and find those cases, find those articles so that it could be incorporated into this book. In addition, we also did some editing, some rearranging of chapters, and ultimately it served as a sounding board to Matt as he drafted all the chapters.
How does it help your practice at Pepper?
I learned a lot through this experience. A lot of it was unexpected, but it was very welcome. When you really, really take a deep dive into the law in the sense that you're going to teach young, inquisitive law students, you really have to understand and know what you're talking about. It's not so much just one area. If you're doing arbitration, maybe you're looking at a motion to compel arbitration or something in the area of practice. But when you are diving in to talk about really complicated areas and explain it, you really have to get into the law and understand the changing of the laws, the new parts of it. And I think in that research, I understood a lot. And also, we made a practical section in this book, a practical chapter, which sort of talked about an arbitration from the beginning to the end, with lots of twists and turns to have teaching moments and practical exercises. And it was in that process that there were a lot of thought-provoking and stimulating problems that I have not come across in my arbitration practice to date, but was able to address and research and sort of think through as we drafted this book.
So I would say much more so than I expected. The book has helped me a lot in my practice at Pepper. With Matt, currently I have one domestic arbitration and one international arbitration. And more than once we have emailed, and one of us had said, hold on, I think there's something in the book about this. And we'll pull out the copy that we have and I'll say, oh yeah, in this chapter here, here's a primer. And so it's helped in that way because we haven't had to go back and do sort of our basic research.
Let me ask you a question, if I can.
Sure.
Do you think that as a young associate, this has given you more of an expertise into a field of law than you might otherwise have gotten just by coming along the usual track?
Absolutely. I think by participating in writing this book, I really got a deep dive into arbitration that otherwise would have taken several years to amass the knowledge that I was able to do. And I'm officially now a third year at Pepper, so in only basically 2.5 years, I was able to research, talk about topics, and really go deeply into every aspect of arbitration, which in my normal practice I have not been able to do.
So I just wanted to follow up on something Kate said, because she's being her typically modest self. The work that the Pepper Associates did on this, our former colleague Chad Holtzman, Kristen Connon, Ryan, and Kate, went well beyond research. And I just, to illustrate that, wanted to expand on the particular point that Kate mentioned. One of the fascinating things about arbitration, wholly in addition to what I mentioned earlier about it being a dispute resolution mechanism, is that it's become a real flashpoint for access to justice issues. Because what's happened is that companies, and I again say this devoid of taking a position on the merits, companies have in their, especially consumer contracts, your cell phone contract, your brokerage contract, the contract you sign if you go and buy tickets on StubHub, have arbitration clauses. Okay, there's good reasons for that. They cut down on court costs. There's less discovery. As I mentioned earlier, there's no appeal. In tandem with that, over the last 15 years, there emerged not only arbitration clauses with consumer contracts, but a waiver of class actions. And I'll explain what I mean by that. That means that if you have a $30 dispute with Verizon, or let's say 12 straight months of a $30 dispute with Verizon, you can no longer band together with hundreds of thousands or maybe millions of other Verizon consumers and push that case through court, because arbitration clauses now contain a waiver of class action. And several Supreme Court opinions that we study in the book have the justices saying, what rational lawyer would ever take a case for $36? To which the answer is, no rational lawyer would take a case for $36. What that means as a matter of social policy in the United States of America in 2017 is that a whole class of consumers, that is, consumers with small claims, are essentially foreclosed from the dispute resolution process, not just from courts, but from arbitration, because nobody's going to bother bringing a case this small. From a social policy standpoint, we wanted to examine that. We wanted to give law students, who are going to be tomorrow's leaders, the pluses and minuses of that. But we also, and this picks up on something Kate just said, wanted to track that debate as it's playing out. And in the last year of the Obama administration, there was an administrative proposal designed to essentially outlaw the class action waiver. In other words, to open arbitration, especially consumer arbitration, back up to class action so that there would be access to court. As with so many things in the Obama administration, it's not clear. It's still not clear whether or not that's going to survive in the Trump administration. And so we really wanted to give an up-to-date part of that. The final thing I'll say on this issue is that this becomes, and I'm now flipping from law school professor to Pepper Hamilton partner, advising our commercial clients, this becomes very, very important when we are looking at our clients' dispute resolution clauses. And I purposely say dispute resolution and not arbitration clauses because our clients have a choice to make. But for those of our clients, especially our financial institutions, which are particularly covered by the regulation, who are looking at arbitration, the question then is, should the clause contain or not contain a class action waiver? And so as Pepper lawyers, we want to be, and we're expected to be, and we should be, absolutely up to date on the regulatory background of the fields in which we're advising our clients. Writing the book was a terrific way to force ourselves to stay abreast of that in a way that, I'll say immodestly, I don't think many lawyers can discuss.
Now, Matt, you do wear different hats, as you said, law school professor and Pepper Hamilton partner. In your mind, who is the audience for this book?
The book's audience is reflective of your question. I have stubbornly resisted in my career doing any one particular thing to the exclusion of others. I think it's one of the beautiful things about a law school degree. I have a daughter who's going to be a lawyer, and I tell her that I don't know what you're going to be, but I do know that with this degree you can be a great many things. Kate Puccio, who's sitting next to me, I hope she becomes a great many things, and she has the talent to do that. And so to answer your question, I want the audience to be reflective of the hats that I've worn. So I want law students to read this book and actually enjoy coming to class. My students seem to, or at least they do a very good job of fooling me and pretending they do. I want it to be a very practical book for them. I want them to understand the case law, and I want them to understand how to win cases. And we have a lot of exercises in there that I think we all wish that we had when we were reading dry case after dry case instead. But full stop and full paragraph to that answer, because I also want the audience of that book to be lawyers who are either drafting arbitration clauses, perhaps they're transactional lawyers, including some in our building, and lawyers who are figuring out how to take a case that they thought might be in court and is now in this weird format called arbitration. And I want them to be able to pick up the book, especially units 1 and 2, and think, whoa, okay, here I am now. How do I pick an arbitrator? How do I get evidence? So we very much want it to be a practical primer. It might not be labeled as a horn book, but I think we really wrote it with the horn book very much in mind. And then finally, we want our clients to be able to look at it as they are sourcing potential candidates to hire for a dispute resolution process, or if I can view it less selfishly, if they're just figuring out how to draft their arbitration clauses and what they should know. So I really tried to write it, we really tried to write it from the standpoint of student and practitioner and client.
And I think we had several discussions while writing the book about how law schools right now are really struggling with what for so long has been a dichotomy between law student and actual practitioner. And one of the reasons why we think our book is so great is because it really pushes these two together and gives the students skills and teaches them things that they will really be able to put into practice, like so many other books unfortunately do not.
I am enough of a traditionalist that I do think that law students should read cases. It's the school figures of the law. And I think unless you're well-versed in reading cases, you're not really able to ultimately be a full-versed lawyer, no matter how much fun law schools may now want to make things. On the flip side, nobody wants to read dry case after dry case, as we said. And so we think that the combination of cases and practice is the way to convey how to be an arbitration practitioner. You simply can't have one without the other. And that's really the balance for which we were aiming.
I know all three of you are very busy, and I really appreciate you giving us some time today. So I will only throw out one more simple question. Why is arbitration important?
Sure, I think that's probably for a longer podcast. But initially, I would say, as a litigator primarily, the courts are packed. When you file a complaint and you get in front of a judge, some of these are taking year, 2 year, 3 years in order to come to a resolution. Arbitration is much different. You can build your courtroom, as they say. You can decide on the, quote, judges or arbitrators. You decide a lot of procedural rules. It's quicker, less expensive. There's less discovery as long as there's a mutual consent of the parties. So we are encouraging a lot of our corporate folks to draft binding and very thorough arbitration clauses in their contracts so that they can then go to arbitration and have really business-friendly litigation, to put it in one sense, to mean that no corporation, whether they're defending their rights or enforcing their rights, wants to go through 3 years to have a judge figure it out. You can have a problem, get to a resolution very quickly in arbitration. And then going back to the clauses in arbitrations, there's lots of changes, and the beauty part of, again, researching this book and going through case law, where there's a lot of situations where it had to go to court, and the court was deciding whether or not this was a valid arbitration clause that should send this dispute to arbitration. And so you see a lot of failed clauses, things that they wrote that didn't work, that ended them up in court, even though they tried to have an arbitration clause and arbitrate the dispute. So certain language, certain provisions that were prohibited or allowed, we could really dig into that and nail it down so we have a very good and binding arbitration clause. I think both parties, when they enter a contract, if it is their desire to arbitrate, you can have a clause that meets that needs, and you can show many cases of why this will be upheld.
I think arbitration is important for something that Matt said earlier, which is really giving people who otherwise might not have access in a timely way to the courts a way to deal with their disputes quickly in a way that hopefully sophisticated parties have chosen to do them, have chosen to participate in arbitration, and really to alleviate a lot of the burden that we have placed on the courts. Additionally, when you come to having sophisticated parties, it permits two highly sophisticated, usually business parties, to come together and say, if we have a dispute, this is how we want to deal with it, and we want to put procedures in place to hopefully deal with it in a much more efficient way than we otherwise would be able to in the court system. And I think that although arbitration has its fair share of critics, and there are definitely things that anyone who practices in the alternative dispute resolution field will want to change about it, it really does have a lot of great advantages.
Yeah, I agree with what Kate said. I would reduce it to it being a bit of the same answer as the famous mountain climber answer when asked why he climbed mountains, and he said because it's there. So arbitration is important because it is now a very significant percentage of dispute resolution, and you can't really be a dispute resolution lawyer or draftsperson about dispute resolution without understanding it. That's the main reason. The second reason is for the social policy reasons we just talked about. I think as lawyers we have a fundamental responsibility, whether we sit in academia, in corporations, in law firms, to think about the profession that we're in and whether folks will have access to court. So for those two reasons, from both a social policy standpoint and from a practitioner standpoint, this is something you simply have to know about. It's no longer an esoteric elective. It's a fundamental part of the American legal system.
Well, I want to say thanks again. We have run out of time. For our listeners, if you're interested in more information about the book, please visit Pepper's Insight Center at www.pepperlaw.com, where this podcast is posted.